So I'd like to welcome everybody. My name is Joni Foster. I'm the Program Director at Economic Growth Business Incubator. And we are a small business incubator on the east side of Austin, helping everyday people start and grow their business. So we provide training, coaching, and some back office services like helping people set up their QuickBooks and learn how to run QuickBooks. We have some virtual office space, et cetera. And we've been around for 10, 11 years as an incubator, and we're here to help you if you need any more help after that. I'm going to put our email address or our web address in the chat when I'm done introducing people, and please feel free to reach out to us. Today, I'm very excited because we have folks from the UT Entrepreneurship and Community Development Law Clinic at the UT School of Law with us today. They've been working on this presentation after working with a couple of our clients, I believe, to help with issues of not getting paid for their construction type work. So they've put together this presentation for you. Today we have Benjamin Whitehead and Marguerite Zamora, who are law students and working in the law clinic under the supervision of Anna Boccini, did I do that right? And Francis Martinez, attorneys who supervise the law clinic and the student laws. I'm not sure what we call you guys, legal students, okay? So with that, I'm going to turn it over to them. I'd love for you as participants to stay on mute. And if you have questions, please feel free to put them in the chat. If you want to know how to get to chat, you basically move your mouse. If you're on a computer, typically at the bottom, a ribbon will come up and there's a chat box. Just hit that chat box and you can send your questions to all, and they'd be happy to answer it during the presentation. And at the end, there'll be a small amount of time to do verbal questions if you have them. But welcome and thanks for joining us. And I'm going to pass it over to Benjamin. Are you going to start or?
I'll let Mark take it away.
Thank you so much. So yes, like Joni mentioned, Ben and I are law students, but we created this presentation under both Anna and Francis's supervision. So Anna is here representing the Equal Justice Center, and kind of attached to that is the Transnational Worker Rights Clinic. And then Ben, Francis, and I are here from the Entrepreneurship and Community Development Clinic. So this presentation is just intended to be an overview on mechanics liens in Texas. And this was prepared by Ben and I, who are law students, and was kind of proofread and approved by actual attorneys. The presentation is based on Texas statutes and additional resources discussing these mechanics liens, including some materials from the Equal Justice Center. So at the end of the presentation, we do have contact information for the Equal Justice Center if you have further questions about your specific scenario. This information is not intended to be a substitute for the advice of an attorney, and we do encourage you to seek advice if you think that you need it for your specific situation. So kind of a general overview, a mechanics lien gives you, the potentially unpaid worker or contractor, a property interest in a piece of real property and land that you improved with materials or labor or both. This is based in Chapter 53 of the Texas Property Code, and you may also see it referred to or written as mechanics, contractors, or material men's lien. There are separate laws governing public projects. This presentation is going to be focused on private projects, so if you have experience or a question about a public project, we do encourage you to reach out to an attorney about your situation. So what this lien is functionally going to do is encourage the owner of the property and that top level contractor who contracts directly with them to be responsible for making sure that all of the contractors, subcontractors, and workers on the project are getting paid correctly. It actually is going to hinder or prevent the completion of the construction project, any sale of the property or borrowing against the property that the owner might try to do. And this altogether creates pressure for the owner and that top level contractor to resolve any payment issues so that they can move on with the project and the land. For subcontractors, the lien claim notice letters that we're going to discuss later in the presentation can require the owner to withhold payments to that top level contractor so that a subcontractor might be paid from these what we call trapped funds. So essentially, instead of paying the top level contractor the full amount, they may withhold a portion of that that can later be used to pay you if everything goes correctly and everything is valid. So if necessary, you can go to court to enforce this lien, force a sale of the property, and take the amount that you're owed from the proceeds of that sale. These liens do take priority over almost all other liens on the property, so they can be a really powerful tool for you. However, they do have strict requirements and deadlines. So in order for the tool to be effective and valid, we do encourage you to seek the assistance of an attorney. So in addition to those trapped funds that the owner might have to withhold if you give proper notice, the owner has a statutory obligation. So no matter what, they are obligated to retain 10% of the value of their original contract as a pool of funds that's available to satisfy any perfected lien claims within 30 days of the completion, termination, or abandonment of the original contract. This statutory retainage is independent of any retainage that you might have if you have a contract on the project. So if you see retainage in your contract, that is likely going to be specific to your work on that project, whereas this statutory retainage applies to all situations and can accelerate the deadlines, which we'll get into a little bit later.
So I'm going to talk a little bit about who might be able to file a lien and use this as a tool when you are not fully paid. So it's going to really focus on workers and contractors who are making improvements to real property. And so the left list under improvements is really what we're talking about, are sort of these longer term changes and improvements that you're doing to a piece of land or a building. So that can be performing or furnishing labor during construction or renovation of a structure. It can also be if you're furnishing or creating a specially sort of ordered or designed part that's going to be installed there later, so sort of specially fabricated materials. It can also include the demolition of structures, so maybe it's being cleared for a new build and you participate just in the demolition process. As I mentioned, something that's going to come in and be installed and physically attached to the land if you're working on that. Even new landscaping. So if you're doing sort of on a newly built site, an extensive new landscaping job, that could be something you can file a lien on. And then also the final post-construction cleaning of a site can also be something that you could use the lien as a tool for. Things that aren't going to be able to use a lien are going to be sort of your regular upkeep of a property. So if you're doing a contract that's just for sort of regular routine maintenance, cleaning, or groundskeeping, those are things that will not qualify. And then also if you're installing something that's not going to be physically attached, but just is there temporarily and going to be moved, that would also not be something you could use the lien process for. And I know we have a quick question about the statutory retainage and who is required to withhold. And so the statutory retainage is the property owner. And so we'll talk a little bit more about how that can work as we get into some of the process. But the property owner is the individual who's obligated under law to retain that amount. So speaking of the roles that are involved here, one of the things you want to do when you start out on a project is try and identify what role you are playing, as well as the other folks involved. And so the law uses some different terminology here, and the probably most important one is going to be this idea of the original contractor. So it's not necessarily just the general contractor if someone has that title in the job, but it's going to be specific to you being the person who contracted directly with the owner of the property. So whoever has that direct contract with the property owner is going to be what's referred to as the original contractor within the lien statutory scheme. And then if you don't have that contract, but if you instead have been someone who's got a subcontract with the original contractor, you're referred to in the law as a derivative claimant, which is really just saying that any sort of lien claim you have is coming through that original contract. And so as you'll see when we get into the notices and some of the other requirements, what that ends up meaning is that you're going to have to provide notice not just to the property owner, but also to that original contractor throughout much of the process. So if you're, again, starting off on a job, you just want to really focus on identifying what role you're playing, whether you are the original contractor with that direct contract with the property owner, or if you're in a subcontractor role for the purpose of the lien statutes. This diagram can kind of just help you think through it. Sometimes the owner may have several contracts that they have directly made. So there might actually be several original contractors on a job. So you just need to make sure you identify which one you have the subcontract through. And there's also the possibility that you could be the original contractor. So especially maybe you're more used to working in a contract setting, but in this case, you're working where a builder is owning the property and doing a lot of the contracting themselves. You might find yourself in that original contractor role. Or if you're normally working just through other folks on subcontracts, you'll be in that subcontractor role. And you'll want to, again, make sure you identify who the original contractor is with that tie to the property owner. And so these roles are important because they change some of the rules for you and the timelines of when you need to do things in order to have an effective lien. And so for original contractors, we'll talk a little bit about the process with Marguerite here in a moment, but you can go directly to filing an affidavit of lien. So you can submit the lien directly to make your claim for that lien on the property. If you're a subcontractor, you have a lot more notice requirements up front. So you're going to have to send some letters earlier on in the process, letting everyone know about your lien claim before you can file the actual claim for the lien. And again, this plays into the idea of the trapped funds because it has to give that owner of the property notice that they should start setting aside money that instead of paying to the original contractor, they're going to keep on the side in case they need to pay it out to you to resolve that.
So getting into the process of actually filing this lien, there are 4 main stages. All 4 of these stages are going to have their own strictly enforced timelines and require some specific information. So we do encourage you to seek legal assistance early so that you make sure that your lien is in compliance with the requirements for your specific project and doesn't get invalidated. These timelines for completing the steps can be short and, like I said, are strictly enforced. So we want to make sure that we're aware of them. The first stage is going to be to send notice to the property owner and your original contractor of the unpaid amount. And then sometimes they might pay you after this stage and then you get to be done. If they do not pay you and you choose to progress, then you can file an affidavit for the mechanic's lien. And then within 5 days, send notice that you have filed and include that copy of the affidavit to the property owner and original contractor. And then if they continue to not pay you, you do have the option to enforce the lien. And if they do pay you, then there's a procedure for releasing the lien. With all of these notices, we remind you to keep copies of everything that you send. These copies may be included with your affidavit when you file and are also good for you to keep for your record keeping purposes. So just a reminder, this process is a tool to encourage the property owner or original contractor to pay you. So if you are paid before you file the affidavit for lien, then you don't have to take any additional steps. Early on in this process, it's extremely important to just remain vigilant and very observant of the project that you're working on. So if you're at all concerned about non-payment or you've had experience with non-payment in the past, do your best as soon as you get on a project to take note of some relevant details. So taking photos of building permits and note of addresses. So we want to also pay attention to that chain of contractors like Ben mentioned earlier. So who else is working on the project, who hired the contractor that hired you, and be sure to make note of who was hired directly by the owner. So kind of going along with that, if you need to request any information, if anything is not evident, you want to make sure that you do this as soon as possible so that you have adequate time later on to get the rest of it together and get your notice sent as early as possible. So if you request information, the contractor and property owner should provide it within 10 days, but you may have to obtain it yourself. So you want to be prepared for that and save time for that. The information that you're looking for is a legal property description to make sure that all of this is tied to the correct property. Some information about any other claims against the property, so surety bonds, existing liens or security interests, and then finally the date that the original contract for the project was executed. I just saw a question in the chat, if the contractor won't tell you who the owner or who the original contractor is, this is kind of your spot to, or your time to do some additional research. And if need be, contact an attorney because they can kind of help encourage people to be a little bit more forthcoming with that information or to seek it out themselves.
And so once you've gathered the information, really the first key step here in the process is going to be to provide that initial notice of the unpaid amount. And so this is going to be a letter that you're going to need to send by certified or registered mail to both the owner and the original contractor if you are a subcontractor on the job. As we discussed before, if you're the subcontractor, you must provide these early notices in order to have a valid lien. It can be in one letter, but it has to have these two parts to it at minimum, which is going to be the notice of the unpaid amount. So this is just, sort of like a bill or an invoice, just letting them know what amount was unpaid and what work it was related to or what materials that you had provided on the job. It's important to note that when you send the unpaid amount, it cannot include any attorney's fees or costs that you're incurring in filing the lien or any interest. And then the second part is that key notice that authorizes the owner to start withholding the funds or to set aside those trapped funds. Again, this is a complex process and it requires some very specific language under the law. And so we do recommend that you contact an attorney for help with drafting these kinds of notices and sending them out because it's got to have that specific statutory language in order to provide the owner of the property the authority to start doing the withholding and trapping of funds so that there can be money available to pay out your claim on the lien in the end. So in terms of the timelines, for this first notice for subcontractors, the dates that we have up here are a little funny sounding because the law is written in a confusing way, but we'll walk you through it. But the main thing I want to emphasize here is that these are really the latest possible deadlines by when you can send the notice. So if you miss this timeline, you would not have an effective claim to a lien. As we mentioned, there are some cases where your timeline might be earlier depending on the specifics of your situation. So that's why it's really important to get this process going early and seek advice from an attorney early on in the process. But generally speaking, the notice timelines break up into two categories, one for residential projects. So if you're working on single family homes, multifamily homes, and then one for any non-residential projects. So for the residential projects, if you are the subcontractor, you must send this first notice about the unpaid amount and the authorization to start withholding or trapping funds by the 15th day of the second month after the work that you performed that you were not paid for. And so a key distinction here is that it doesn't relate to when you failed to receive payment from the person, but when you actually did the work. So for example, if you had performed some work in January and then were not paid for it, the deadline is going to be March. Even if you sent a bill in February and we're sort of waiting to see if they would pay you, the deadline is going to start from the time the work or the materials were provided back in January. For non-residential projects, if you're working directly for the original contractor, you need to send the notice by the 15th of the third month. So you have a little bit of extra time on a non-residential project. But if you're working for another subcontractor, there's a little bit of a different layer here, which is that If you're sort of further down that chain and working for a subcontractor, the notice needs to go to that original contractor by the 15th of the second month. And then you have until the third month to get the notice to the owner. And so, as I said, you can always send these notices earlier than these deadlines. These are going to be the last possible ones. And just as a reminder, these original notices of the unpaid amount are for subcontractors and not for original contractors. And Anna, I think you had to happen.
One small clarification. Yes, these are generally the last possible deadlines, and we do stress that often it's best to get it out much earlier than the last possible deadline, but there are certain circumstances where you might be able to move up one rung in the chain if you can show that the original contractor is really is so similar. There's overlapping officers and directors. If the owner and the original contractor, even though they're separate legal entities, can control each other, it's a sham contract. You don't need to know that or know exactly when that might happen. But I would just encourage you, even if you think you're too late, if you still seek the advice of an attorney, it might be possible that there is still a chance, but you don't want to depend on that by any means.
Thank you. Yeah, so as Anna is pointing out, these are going to be not just complicated legal requirements you have to meet, but also the complicated contract structures that y'all are working within. So it can change your situation. So again, that's why we're really recommending that use this presentation as a way to get some general information about how this process can work, and then talk to an attorney about any specific time if you're interested in starting to send some notices and pursue a lien. So again, the dates of the deadlines, as Anna mentioned, always advisable to send it earlier. And the main reason for that is to ensure that you can trap those funds. Because again, the first notice, the main point of it there is to make sure that the owner knows to start setting aside those funds and not pay them out to the original contractor. And so if they have already paid everything out and don't owe anything to the original contractor, then there's nothing left for them to set aside to be trapped to pay out your lien claim. So again, just make sure you're aware of the timelines, but start early talking to an attorney to make sure that they can figure out the particulars of your situation. And so one thing we did want to notice is that, or to let you guys know, is that you may have to send repeated notices if you have work that's stretching for more than 1 month. So you'll want to send a notice for each month where you go unpaid for the work. So if you had a job that you worked in January, and then you also did some more work or provided more materials in February, and you were not paid for both of those, you would need to send a notice for each of those months to let them know the unpaid amount and to authorize the withholding for that particular month. So that's just something to keep in mind, is you might have to sort of send these updated notices if there's additional work done that goes unpaid in another month. And just to reiterate, if you're a subcontractor and you miss one of these deadlines or fail to include the appropriate language, and get this notice to both the original contractor and the owner, that can invalidate your claim. So it's really important that this initial step is done very carefully. And as we mentioned, anytime you're sending these notices, we recommend using certified mail with return receipt. You're only required to do certified or registered mail under the statute, but the return receipt is a smaller marginal cost and just gives you guys some additional documentation to show that you did provide that notice and that it was received. And then once again, when you are sending these notices, just always make sure you maintain a copy for yourself. You can include it with your affidavit or just keep it in your files to make sure that you have the evidentiary support for your claim if you need to enforce it later.
Okay, so once you've sent your notices, if you have still not been paid, then you can file an affidavit. In general, to do this, you're going to need information about the people and the property. So this is why we encourage you to collect information as early as possible before there's a problem, so that you can hopefully avoid some of that feet dragging or people not being forthcoming with the information. You'll also need a description of your work and the non-payment, and copies of any of the notices that you have sent so far. So more specifically on the affidavit itself, you will have to include the name and address of the person who employed you, name and address of the original contractor, this might be the same person, name and address of the property owner, a legal property description. So again, this is a description that's on the property record so that it can be legally tied to the correct piece of land, your name and address, And then the total unpaid amount, a general statement about the kind of work done or materials furnished by you if you did provide any, and then a list of months where the labor was not paid for. A statement identifying the date of each notice of the claim that was sent to the owner and the method by which that notice was sent. So you would just say, December 1st, certified mail. And copies of any written agreement, invoices, work orders, and a copy of each notice sent to the owner or original contractor, again, using that certified mail, keeping the return receipt for your own records. And then finally, this is an affidavit, so it will need to be notarized and signed. So you want to save some time at the end to make sure you can get to a notary. Where to file? So you're going to file this in the county clerk's office where the property that you worked on is located. So I know in Austin, it's not always super clear where the county line is. So you want to make sure that you're aware if you're working in Williamson County or Travis County or Hayes or wherever you happen to be working. These filing requirements for formatting and for cost do vary by county. So you want to make sure and check with the county clerk. Some of them have this information on their website. Some of them you may have to call. And the filing costs also vary by county. So generally in Central Texas, they range from $11 to $26 for the first page, and then they're going to be $4 for each additional page. These timelines continue to vary. So if you're on a residential project, you will file at the latest by the 15th day of the 3rd month after you stopped working. So if you stopped working in January and went unpaid for that work, your last day to file is going to be April 15th. And then if you have a non-residential project, you get 1 extra month if you need it. So if you stopped working in January and went unpaid for that work, your absolute last day to file is going to be May 15th. In many cases, so like Ben has alluded to, the best practice is going to be to file within 30 days of your last work on the project. This is just to make sure that when your lien claim goes through, there's still money remaining that is available to pay you. It is recommended generally that you consult with an attorney to ensure that you're complying with all of the requirements, so you're not going through this process only to find out that your lien was invalid.
And so the next step is going to be making sure you send a notice after you file your lien to both the original contractor and the owner of the property. And this is within 5 days of filing. So it's the shortest deadline in this process. It does require strict compliance, so you have to make sure you meet that. So best practice is probably to go ahead and once you filed your lien, make sure you get copies of it and send those off the same or next day to make sure you're within this timeline. As with the other notices, go ahead and make sure you send it by the certified or registered mail, and we would recommend using the return receipt so you know that the other parties received the copy of the affidavit that you sent them after filing it. And so then the last step in the process essentially has 2 possible outcomes, right? One is that if you are still unpaid, then you can enforce the lien, and we'll talk about what that entails, but it does require going to court. And then if you have been paid after you've filed the lien, then you do have to take some steps to make sure that the lien is released. And so we'll also talk about those in that circumstance. So for enforcing the lien, again, this is if you have not been paid. You have these 2 timelines between the residential and non-residential. And it does require going to court. So we recommend first always seeking the advice of an attorney so that they can help you make sure that your lien is compliant before you go through with this process, and then help you with the filing the action in court. But for a residential project, you would have to start your action to enforce the lien within 1 year after the last day that you could have filed, or the last day of that original contractor's contract with the owner. And it's whichever of these dates is later. So if there's an original contract that's extending for more than a year, you might have some more time, but usually it's probably going to be within that 1 year time frame. And then similarly, on non-residential projects, you must file that action to enforce the lien within 2 years after the last day that you could have filed that affidavit, or in this case, within 1 year of the end of that original contract. So whichever one is later of those. And so just as a reminder, if you're gotten to this point and you still haven't been paid, it's definitely time to go and talk with an attorney and make sure that they've checked over everything and that you meet these deadlines for filing in court. On the other hand, if you have been paid, but you've already filed that lien of the affidavit for the lien in the county clerk's office, then there's some additional procedures that you need to go through to make sure that the lien is released from the property. And so the main thing is that after you've been paid, you have to provide a recordable lien release. So it's going to be a simple statement, about releasing your lien from the property that you will provide within 10 days to the owner or the original contractor, or if it's a subcontractor who's paid you, just confirming that you've been paid and saying that you're releasing the lien that you claimed on the property. At this point, it might depend on whether you're going to go down to the county clerk's office and file this, or the property owner likely may want to do it, or the contractor who's paid you. But our recommendation is just make sure you know who's going to be responsible for filing it in the county's clerk's office. And if you're not clear on it, you may want to go down and check the records and file it yourself, just to make sure that you've closed up all the loose ends here and that the lien has been released. And once you have done that and you know it's been released, you're going to want to just send a notice to both the property owner and the original contractor, just to make sure everyone is in the loop and knows that the process has been resolved and you've been paid.
There are some additional special rules if you're working on a homestead property. So this is any property where the property owner is living there for their primary residence. So this does not include vacation homes or anything like that. It is much harder to file a lien on a homestead because Texas has rules to protect these property owners. So there, in addition to all of the rules that we've just discussed, the original contractor that you worked under must have a written contract with the homestead owner. And if the owner is married, then both they and their spouse must have signed that original contractor's contract. The contract then must be filed with the county clerk. And then your lien will need to include some additional special statutory language. So if you are working on a homestead, it's going to be extra important to contact an attorney and make sure that you are checking all the boxes and following all of the rules for these special properties.
And then one other area we wanted to talk to about was lien waivers. And so this is something that we know comes up in a lot of contracts. But if you've been asked to sign a lien waiver, these are agreements that would waive your right to claim the mechanics lien in exchange for payment. And so usually you'll see these when you're requesting progress payments or during final payments. The things we want you guys to know about them is that they are valid. These lien waivers are allowed, but they are disfavored under the law, which means that there's a lot of strict legal requirements that the lien waiver has to comply with in order for it to be a valid waiver of your right to claim the lien. And so we're going to share with you some of the key ones of those. So primarily, for a lien waiver to be valid, it needs to be in writing. There's very specific statutory language that it should include. It needs to be signed and notarized by you when you're waiving your right to the lien. And then also it has to be supported with evidence of payment. There is an exception for this, which is that if you're working on a single family residence, then if the lien waiver is included in the written original contract up front before you started providing any materials or furnishing any labor, then that can also be valid, but it's got to be upfront in that written contract. So if at any point you are presented with a lien waiver that you're being asked to sign and you have questions about it, or you think it doesn't meet these types of requirements, we definitely recommend consulting an attorney to make sure that you're not signing away rights or that you're aware if there's a problem with the lien waiver. A special sort of subset of this are unconditional lien waivers. So this would be a waiver that is not triggered by anything. It's just a signing away of your right to claim the lien. The important part on these is that you cannot be asked or you cannot be required to sign an unconditional waiver of your right to claim the lien unless you've already received the payment. So this is something where maybe if you have been fully paid, the contractor might follow up and say they'd like you to fill out this waiver, an unconditional lien waiver, to just make sure that for them that they're protected and everything sort of closed off and resolved. The same exception though does apply here, that if you're working on the single family residence, an unconditional waiver could be included in that original written contract before you start work on the project.
So just some final reminders before we close tonight. The 4 main stages of this process are going to be sending that original notice to the owner and the original contractor of the unpaid amount. And then if you remain unpaid, you can file an affidavit for a mechanics lien, following up within 5 days of the notice and copy of the lien to the owner and original contractor. And then finally, if you remain unpaid, you can enforce the lien, or if you have been paid, you'll release the lien. So big things to take away from this presentation. We want to encourage following the timelines. They are strictly enforced and very important to the validity of your lien. And we want to make sure you're including any required information in notices and in your affidavit, using certified mail with return receipts for your own records, and keeping copies of everything that you send, both so that they can be included in your affidavit, and again, just for your own records. And throughout this process, we encourage you to seek the advice of an attorney to make sure that you are taking all of the right steps for your specific situation. So some quick additional resources. These first 2 from the State Bar of Texas and Texas C-Bar are going to include additional guidance similar to this presentation with a little bit more detail. And they also include examples of the notice letters and the affidavit of lien forms that we've mentioned throughout. Below that, if you have questions about your specific case, we encourage you to contact the Equal Justice Center where Ms. Bocchini works. And then if you have questions about other business matters, such as formation or contract questions, you can reach out to us at the Entrepreneurship and Community Development Clinic, the law school. I got a quick question in the chat about if you can ask for payment of legal costs. The lien is only for cost of your labor or materials that you furnished for the project. So you cannot include legal costs in the lien.
Yes, in your lien affidavit, it's only covering the unpaid amount due. However, in action to enforce the lien, you are entitled under the statute. And it depends again on which type of job. If you're on a residential job, it's discretionary, but the judge may award attorney's fees as are equitable or just. And similarly, in the commercial project, it's a mandatory fee award, but it could go to either party, but depending on the outcome of the case. But yes, you can get them, but the lien does not secure them, and so you can't include it in the lien affidavit an amount covering costs and attorney's fees.
And then we also got a question about what is the Equal Justice Center. Anna is one of their attorneys, so I'm sure she can speak to this.
We are a nonprofit law firm, and we have a couple attorneys who practice some immigration law, but we mostly practice employment law on behalf of low-wage workers. But we also have an expertise in construction law and represent people who a lot of people are misclassified on construction sites. But we also do represent genuine independent contractors in construction law claims, and we also provide free advice and counsel to anyone who calls, even if we're not able to represent them on a specific claim.
And I know we have another question here about going back to the initial question of who might be able to use a lien. And so this is for if you're installing erosion control on a commercial site. And so something that's going to be installed as a temporary structure to help prevent that erosion, and then removed at the end of construction, whether or not that would be considered something you could file a lien on. Anna, do you have any initial thoughts on that?
I don't know specifically off the top of my head, but I would assume that that would constitute labor that goes into the construction and would likely be something that would qualify. And with respect to the statute does have specific provisions if you are attempting to recover contractual retainage. and you may need to send a separate notice if your contract provides for retainage to be withheld from amounts due to you for labor or materials provided for the construction. And if it's, because usually you need to get it by the 15th day of the second month after you go unpaid. Obviously, if you have a contractual retainage provision, the money may not be due to you. You may not know it's unpaid. So if you give the owner a notice earlier on that, hey, I have a contract that provides for retainage, the owner is on notice, and then your deadlines are more lax with respect to when you actually have to let them know and get a lien out for unpaid contractual retainage amounts. But again, very strict and specific requirements. And so if you have a specific question about a certain project or incident that has occurred to you, you should seek legal advice about that specific situation.
Do you have any additional questions? And if you have anything really specific, it is being recorded, so I don't want anyone to disclose any details they're not comfortable disclosing.
So I want to thank our presenters.
Thank you, Joni.
Thank you.
Oh, funny, Leo's coming. So I thought that was really great, and I'm glad we recorded it. So I appreciate you doing this for us.
Oh, thank
And
you very
Anna,
much.
I think I'm going to follow up with you down the road for some specific questions that a lot of our clients have about labor law.
Okay.
All right.
Wonderful.
Yeah, no, thank you.
Thank you. It was great to meet you.
Yeah.